Good evening, sir. My name is Mr. Delacerno Milar Jr., Cream 1, Black B. Section 1. Preliminary investigation defined. When required preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty, theory, and should be held for trial. Except as provided in Section 7 of this rule, a preliminary investigation is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed by the law is at least 4 years, 2 months, and 1 day without regard to the fine. Section 2. Officers authorized to conduct preliminary investigation. The following may conduct preliminary investigation. A. Provincial or city prosecutor and their assistants. B. Judge of the municipal trial court and municipal circuit trial court. C. National and regional state prosecutor. And last, other officers as may authorized by the law. Their authority to conduct preliminary investigation shall include all crimes cognizable by the proper court and their respective territorial jurisdictions. Section 3. Section 3. Procedure. The preliminary investigation shall be conducted in the following manner. A. Complaint shall state the address of the respondent and shall be accompanied by the affidavit of the complainant, his witnesses, as well as other supporting document to establish probable cause. They shall be in such number of copies as the respondent, plus 2 copies for the official file. The affidavit shall be subscribed and sworn to before any prosecutor or government official authorized to administer oath or in their absence or unavailability. Before a notary public, each of whom must certify that personally examine the affiant and that is satisfied that they voluntarily executed and understood their affidavit. B. With 10 days after the filing of the complaint, the investigation officer shall either dismiss it if he find no ground to continue with the investigation or issue a subpoena to respondent attaching it to it a copy of complaint and its supporting affidavits and document. The respondent shall have the right to examine the affidavit submitted by complainant which he may not have been furnished and to copy them at his expense. If the evidence is voluminous and complainant may be required to specify those which he intends to present against the respondent, and this shall be made available for examination or copying by the respondent at his expense. Object as evidence need to be furnished a party but shall be made available for the examination, copying, or photographing at the expense of the requesting party. C. With 10 days from receipt of this subpoena, with the complaint and supporting affidavits and document, the respondent shall submit his counter affidavit in that of his witnesses and other supporting document relied upon for his defense. The counter affidavit shall be subscribed and sworn to and certified as provided in paragraph A of this section, with the copies duly furnished by him to the complaint. The respondent shall not be allowed to file a motion or dismiss in lieu of counter affidavit. If the respondent cannot be subpoenaed or his subpoena does not submit in counter affidavit within the 10-day period, and investigating official resolve the complaint based on the evidence presented by the complainant. E. The investigation officer may set a hearing if there are facts and issues to be clarified from a party or witness. The parties can be represented at the hearing, but without the right of examine or cross-examine. They may, however, submit to the investigating officer questions which we ask the party or witnesses concerned. The hearing shall be held within 10 days from submission of the counter affidavit and other document, or from expiration of the period for their submission. It shall be terminated within 5 days. Within 10 days after the investigation, the investigating officer shall determine whether or not there is sufficient ground to hold the respondent for trial. Thank you, sir.